black teenager in Texas suspended over the length of his hair is not giving up his legal fight against his old high school. If you're not familiar with Darryl George, we're going to bring you up to speed now. For most of the school year last year, George served what's called an in-school suspension, essentially for refusing to cut his hair. George's long locks violate the school's dress code, which mandates shorter hair for boys. As a compromise, he wore his hair basically in a bun of sorts on the top of his head, but that didn't change the school's stance, and neither did a state law approved last May that bans schools from race-based hair discrimination. George sued, claiming racial bias, but a judge ruled against him. He then left the school district, but today he asked a judge to let him go back, long hair and all, while the case plays out. Joining me now is civil rights attorney Adanté Pointer. Adanté, thanks for being here. Darryl George wants to return to the school that suspended him with stipulations. So now he's asking a federal judge for a temporary restraining order against further punishment from the school while his case plays out in court. A judge today said a ruling would be coming soon. What will this judge consider to ultimately make a decision in this case?
Well, the judge will be looking at whether or not the student is actually going to be subject to further discrimination. And also, what's also very important, critical to this is George is currently not enrolled in the school. He withdrew from the school district. So the school district is actually arguing, saying that he doesn't have standing, that he legally cannot bring such a case nor ask for the restraining order from the judge. So the judge has a pretty dicey decision to have to decide upon as to whether or not George is even properly before the court for this issue.
And that's really what the school district responded in court documents filed last week, saying the judge does not have jurisdiction because of what you just said. What are the guidelines when it comes to that? Because he was enrolled, then wasn't, and now wants to be re-enrolled.
Well, George's position is, look, I went to the school, I suffered a bunch of punishment, and when I came back for my senior year, I was subjected to the same type of punishment, being placed in on-site or in-school suspension, being deprived of my education. And with that being said, they essentially forced me to withdraw, or else I would have to continue going through this. And I'm asking you, the court, the judge, to allow me to come back to school and not face that same level of treatment. So that's what the dispute is on just a primary basic level. But overall, George is hoping that he can attend his senior year of high school without being subject to the same type of treatment and what he calls harassment and punishment that the school gave him for having long hair.
How does the Crown Act factor into this case?
Sure. The Crown Act is an act that was adopted by the state of Texas that essentially says that people cannot be prosecuted for wearing their natural hairstyle, that you cannot be discriminated against because you're wearing what's natural to you. And so that has factored into this case because that is what George was relying upon to get the court to overturn what the school had did in terms of disciplining him for having long hair. You know, it seems to me that there would be some sort of compromise here if he was able to wear his hair up and not wear it down. But the school district is not backing down from what they feel is their requirement or what they're seeking to do, which is to instill discipline, hygiene, and respect for authority through their policy as it relates to hair.
And speaking of that, it's a dress code issue, essentially, is what the school is saying. What are the limitations, if any, to creating a dress code? Where, I guess my question is, where does a dress code cross over into violating people's personal rights?
Well, that's the question before the court in some ways. Is the dress code such to where it's violating people's personal rights? This fight now that we're seeing play out in Texas is essentially encapsulating that. A student saying, hey, I'm just doing what's natural to me. This is my natural hair. Why should I be persecuted for being me, for the status of being an African-American male whose hair grows in a particular way? While the school district is saying, look, we have these rules, these policies are enforced regardless of race or gender. This is the way in which we want our students to show up. The judge in George's case has said, essentially dismissed all the racial disparagement or racial discrimination claims and is only willing to allow George's case to go forward on gender discrimination claims. So that's going to be an interesting point of which the court will now have to pivot to in terms of evaluating the Crown Act and how it plays out in schools across America.
It is a case to watch, that's for sure. Adanté Pointer, civil rights attorney, thanks so much for your time. Appreciate you.